that I didn't get to know Isabella while making the movie because we met a couple times, but we weren't working together.
Yeah.
And Colleen is really the one who, Colleen connected with me, but Colleen was incredible in saying, like, okay, the book is one thing and the movie also is another thing, and we have to make sure that we're not making a replica of the book if it isn't always the best and most authentic choice for the moment. And I think because of that, it's a very true adaptation of the book. Like, it is very, very, very true to the book.
Blake Lively's explosive lawsuit against Justin Baldoni just hit a massive roadblock, and the tea is absolutely scalding. We're talking about a legal filing so brutal it could wipe out almost her entire case, leaving nothing but contract drama behind. The glamorous actress who thought she had Hollywood's biggest harassment scandal on her hands might be watching it all crumble before her eyes. And the reason why is absolutely wild. Wayfarer Studios just dropped a legal weapon called a judgment on the pleadings, and it's systematically tearing apart every single claim Blake made. This isn't your typical motion to dismiss. This is a surgical strike aimed at the heart of her allegations, questioning whether her lawsuit even meets basic legal requirements to proceed. The filing reads like a legal thriller, pointing out gap after gap in Blake's complaint, from jurisdictional issues to timeline problems to missing signatures on crucial documents. If the judge agrees with even half of what Wayfarer's arguing, Blake's bombshell case could be reduced to almost nothing, and the implications are staggering for everyone involved. Here's where the first major crack appears in Blake's legal strategy, and it's a big one. Blake filed a huge chunk of her lawsuit under California's Fair Employment and Housing Act, which sounds solid until you dig into the details. But that's not all. Blake is a New York resident. The movie It Ends With Us was filmed entirely in New York and New Jersey. Every single alleged incident of harassment happened on those East Coast sets, nowhere near California. And here's the kicker. California law has this fundamental rule that says it doesn't apply to conduct that happens outside the state unless the legislature explicitly says otherwise. Wayfarer's lawyers are hammering this point hard, citing cases like Sullivan versus Oracle that establish this territorial limitation. They're telling the judge that Blake can't cherry-pick California's employee-friendly laws to sue for things that happen 3,000 miles away. The alleged harassers were in New York and New Jersey during filming. The decision-makers she's blaming weren't in California either. One defendant was in Illinois. There's simply no California connection strong enough to justify applying California law, and without that foundation, a massive portion of her case collapses before it even starts. Now this is where things get seriously complicated and messy. Blake keeps trying to blur the lines between Wayfarer Studios and It Ends With Us LLC, treating them as interchangeable entities. It gets even worse. Legally, they're completely separate companies, and that distinction matters enormously in employment law. When Blake filed her initial complaint with California's Civil Rights Department, she named Wayfarer Studios as her employer. But here's the problem. Her actual employer for the film was It Ends With Us LLC, a production company created specifically for this movie. This isn't unusual in Hollywood. Studios routinely create separate LLCs for individual films to protect themselves from liability and handle payments, taxes, and employment records separately. Blake's contract, her paychecks, her entire employment relationship was with the LLC, not Wayfarer Studios. Her own complaint includes a copy of her agreement, and the signature line clearly states it's between It Ends With Us Movie LLC and Blake B. Inc., not Wayfarer. By never naming her actual employer in the civil rights complaint, she never obtained the legal right to sue them for employment discrimination. It's a procedural requirement that can't be ignored. The drama doesn't end here because Wayfarer just dropped an absolutely nuclear revelation. And here's where it gets wild. In their filing, Wayfarer's lawyers revealed that Blake apparently never signed her employment contract. Read that again, slowly. The actress suing for breach of contract violations allegedly never executed the actual contract she's claiming was breached. Wayfarer had to file an unsigned copy with the court because, according to their filing, no signed version exists from either party. This is genuinely stunning because employment contracts are the foundation of every single one of Blake's claims. How do you prove someone violated the terms of an agreement if you never actually signed that agreement? How do you establish what your rights and obligations were without a binding contract? Blake conveniently never included a copy of her signed contract in her own lawsuit, which now makes perfect sense. She didn't include it because apparently it doesn't exist. If this holds up under scrutiny, Blake's entire contractual basis evaporates. You simply cannot claim breach of contract without an executed contract. It's Contract Law 101, and somehow this fundamental element is missing. Let's talk about Blake's retaliation claims, because the timeline is absolutely devastating to her case. Things take an unexpected turn when you actually look at the dates. To prove retaliation under employment law, you need a close connection between your complaint and the alleged punishment. The legal term is temporal proximity, and it matters immensely. Blake claims she first raised harassment concerns in May 2023. The supposed smear campaign she's complaining about started in August 2024. That's a 15-month gap. Courts have thrown out retaliation claims with gaps of 7 months, even 10 months, because the connection becomes too weak to establish causation. 15 months is an eternity in legal terms. Wayfarer's filing cites case after case, showing that such lengthy delays break the causal chain. Even if you use Blake's January 2024 all-hands meeting as the starting point for her complaints, that's still 7 months before the alleged retaliation. She would need to prove that 7-month gap is directly connected, and she hasn't. The filing argues that hiring Crisis PR in August 2024 would have happened regardless of any complaints from over a year earlier, because it was responding to immediate public relations disasters, not ancient harassment allegations. Here's what Wayfarer's team is arguing about the whole PR crisis management situation, and it's compelling. And listen to this. They're saying the text messages Blake presented as smoking gun evidence of a coordinated attack prove the exact opposite of what she claims. According to the filing, those messages show Baldoni's team preparing to defend themselves against anticipated negative publicity from Blake and her powerful PR machine. The timeline is crucial here. This wasn't retaliation for year-old harassment complaints. This was emergency damage control for a very public feud that exploded during the film's premiere in August 2024. When Blake had cast members unfollow Baldoni on social media, refused to be photographed with him, and allegedly had him and his family hidden in a basement during his own movie premiere, his team scrambled into crisis mode. The text messages talk about being armed and ready and planning for scenarios where Blake makes grievances public, which is standard crisis management, not evidence of retaliation. Wayfarer argues that defending your reputation against public attacks isn't an adverse employment action. It's self-preservation, and Blake doesn't get to weaponize feminism accusations and then cry foul when the other side defends themselves. Everything seems to trace back to that explosive August 2024 premiere, and the details are wild. Things get even messier from here. Blake effectively sidelined Baldoni at his own movie premiere, creating a spectacle that immediately sparked gossip site speculation about behind-the-scenes drama. She instructed cast and crew members to unfollow him on social media, a deliberate public signal that something was wrong. She refused to be photographed with him, denying the standard joint press opportunities that promote films. And according to Wayfarer's filing, Baldoni and his family were banished to the basement until Blake finished her pre-show appearances. Imagine being the director of a film and being hidden away at your own premiere like you're some kind of embarrassment. This wasn't subtle. This was a calculated public freezing out that guaranteed media attention and speculation. Baldoni's team watched this unfold in real time and knew the headlines were coming. Reddit threads started popping up about competing film cuts and on-set feuds. Gossip sites went into overdrive. That's when the crisis management kicked in, and Wayfarer's lawyers argue this timing proves everything. This wasn't retaliation for complaints from 15 months earlier. This was a director trying to salvage his reputation when his lead actress publicly humiliated him. But here's the kicker that could doom Blake's entire employment discrimination case. The reason this happened will shock you. Before you can sue for employment discrimination in federal or state court, you have to exhaust administrative remedies. That means filing with the appropriate civil rights agency, going through their process, and getting what's called a right to sue letter. Blake did file with California's Civil Rights Department, but she made a critical error. She named 10 defendants in that complaint: Wayfarer Studios, Justin Baldoni, Jamie Heath, Steve Sarowitz, Melissa Nathan, and various PR agencies? Notice who's missing. It Ends With Us LLC, her actual employer. Without naming your real employer in the administrative complaint, you don't get the right to sue them for employment discrimination. It's not a technicality you can hand-wave away. It's a mandatory procedural requirement, and Blake didn't meet it. Wayfarer's filing hammers this point repeatedly, arguing that the employment discrimination claims against It Ends With Us LLC must be dismissed because Blake never exhausted her administrative options. She essentially sued the wrong entity, and you can't fix that mistake after the fact. More than 300 days have elapsed since the alleged incidents, so she can't go back and refile correctly. The window has closed. This is where it gets downright chaotic, and the irony is absolutely delicious. What came next surprised everyone. Blake is now demanding that her Civil Rights Department complaint be sealed and kept confidential in court proceedings. She's literally asking the judge to treat it as a secret document. Here's the problem. That exact same complaint was leaked to and published by the New York Times, becoming the foundation of the massive international media storm that launched this entire saga. Blake's team gave it to the press. It went viral globally. Every gossip site, entertainment news outlet, and tabloid covered it. And now, she wants it hidden from the court record under claims of confidentiality. Wayfarer's lawyers are having an absolute field day with this contradiction. They're pointing out that Blake can't simultaneously use the press as a weapon for maximum public impact, while claiming privacy when it becomes legally inconvenient. The document is already public. It's been analyzed, quoted, and dissected by millions of people. Claiming it's confidential now is not just hypocritical, it's legally absurd. The filing makes clear that this contradiction undermines Blake's credibility and raises serious questions about her litigation strategy. So here's where everything stands. And the stakes couldn't be higher for Blake's entire case. And it doesn't stop there. If the judge grants Wayfarer's judgment on the pleadings, Blake's massive 15-count lawsuit with explosive harassment allegations, retaliation claims, hostile work environment charges, defamation counts, and conspiracy theories could be reduced to just 2 breach of contract claims. That's the difference between a Me Too moment that captivates the world and a mundane business dispute that settles quietly. Everything about sexual harassment gets dismissed. All the retaliation allegations disappear. The smear campaign narrative evaporates. What remains is essentially, did someone violate a non-retaliation clause in a contract that might not even be signed? That's not the stuff of headlines. Even if the judge denies parts of this motion, Wayfarer has laid the groundwork for summary judgment and appeal. They've created a detailed record of every weakness in Blake's pleading. The unsigned contract, the wrong employer named, the jurisdictional problems, the timeline gaps, the missing administrative steps. It's death by 1,000 cuts, and Blake's legal team has an uphill battle ahead. The judge has already shown he follows the law strictly by dismissing parts of other defendants' claims. If Blake's case doesn't meet legal requirements, it doesn't matter how sympathetic her story sounds or how much public support she has. The law is the law, and right now, the law isn't on her side.